Hello and welcome to Daily News Simplified, where we take up the articles from the Hindu and discuss them as per the demands of civil services examination. The topics of the discussion are listed on your screen. On your screen is the question of the day. The question pertains to the science and technology section and asks about the eradication of tuberculosis. Now the topic has been discussed by Jatin sir on the DNS dated 23rd March 2023. Do answer the question in about 250 words and submit them on the eLearn platform to get it evaluated from the expert evaluators at the Raus IAS study circle. Moving on to the first article of the day that has featured on page 6 of the Hindu, basically highlights a spotlight case study of Maharashtra. Now the spotlight gives a detailed report on the farmer suicide case in Maharashtra, under which it is explained that the widows of the farmers are still clearing the debts that their husbands have taken. Now we'll try to understand this report from the GS4 perspective of our UPSC examination. We'll try to analyze the ethical issues that arise from the case of farmer suicides. Now farmer suicides has been covered multiple times under the economy section or the economy problem or the problems that are basically related to the agricultural sector, the areas that are causing distress in the agricultural sector. During this discussion, we will discuss the farmer suicide as an ethical case study, that what are the ethical issues that are coming out of the increasing rates of farmer suicides, and particularly from this case where the widows are still clearing the debts that have been taken by their deceased husband. So the ethical issues that are involved under the case, and the first one which can be identified is the failure of the state. Now, it is the failure of the state as state under a social contract is morally and legally obligated to protect and promote the welfare of the subjects. But in this case, the report highlights that the money lenders have been taking advantage of the underdeveloped or inadequate financial system that has caused distress to the farmers, which ultimately led to their suicide, and the government has not been able to take preventive or curative steps for the same. Now, this not only highlights the failure of the state in ensuring the social contract, but this also highlights the failure of the state to guarantee rights as under Article 21 of the Indian Constitution, that is right to life, which includes right to livelihood, which has been interpreted by the Supreme Court in various judgments as right to life also includes the livelihood option, which is necessary to sustain life with dignity. Now, moving on to the second ethical issue that is represented with this case is the exploitation of the human, wherein we can see human as just a means rather than being an end in themselves. And this case also highlights two-way exploitation at the hands of moneylenders of the loan-taking farmers. The two-way exploitation is testified by the fact that first, the moneylenders charge very high interest rates to the tune of 30 to 40%, and at the same time when the farmer is not able or fails to fulfill the repayment guidelines, then these moneylenders offers very low wage. These low wages are approximately half of the normal wages that these farmers will have get, but due to non-payment of interest or the principal at time, the farmers are now forced to work for these moneylenders on their own land on very low wages. Thus, this highlights the two-way exploitation that has been carried out by the moneylenders in this situation, and humans being treated just as a means to secure wealth and money for the moneylenders. The third ethical issue that this case highlights is the lack of compassion. Now, if we see this report, it can be concluded that the widows are still paying for the debts that have been taken by their deceased husband or by the deceased family members. Now, this is a clear-cut testimony of the fact that there is no compassion or empathy being shown by the family of moneylenders towards the family members of the deceased or to the deceased himself. And this highlights the gray area of desensitization. The fourth ethical issue that this case highlights is the future of children that is at risk. meaning thereby as the families of the deceased are still indulged in the repayment or the debt clearing cycles, the children belonging to such families are not able to attend school due to the paucity of money, and this ensures that the system continues in perpetuity wherein the education of the children is compromised, and also it may sometimes give rise to child labor, as after the family has witnessed the incidents of suicide, the children of the family may now be employed to ensure the livelihood for the deceased family. Another ethical issue that this case highlights is the wealth without work concept. Now, this is particularly important if we see the Gandhian sins or the seven sins of Gandhi. Money lenders here are making wealth without work. They are charging very high interest rate, and this is regarded as one of the sin by Mahatma Gandhi. Now, this report also highlights the rising inequality which is perpetuated in this region of Maharashtra. Now, the same region is hit by drought, that is, it is a drought prone area where the farmers' income have been failing and they are not being able to repay on their debt guidelines. But at the same time, it highlights the accumulation of wealth for money lenders. And the last ethical issue that this case highlights is the lack of motivation. Now, this lack of motivation is present among the farmers because if they go for overproduction, then also due to cobweb phenomena, there may be a case wherein in the anticipation of better remuneration, utilizing the previous year data, the farmers may go for overproduction. But this overproduction will result in oversupply and could possibly result in the demand supply mismatch. This demand supply mismatch will cause the prices to fall down, as it was recently witnessed few days ago in the case of onion pricing being slumping down to the lowest level and farmers bearing huge cost and not able to even recover their production cost, and this results in net loss for the farmers. On the other hand, the farmers also suffer from the case of less production because still they would not be able to generate remunerative prices for themselves and will be perpetuated and stuck in the debt cycles at the hands of money lenders. And this highlights that the farmers are now less motivated towards farming, and can be also testified by the fact that majority of youth today is moving away from the agriculture, and this is not only detrimental for the farmers but it also compromises on the food security issue for general public at large. So these are the ethical issues that can be inferred from the particular case study which highlights the case of farmer suicides and the issues generating from it, wherein it is a failure of state, exploitation of one human at the hand of another, absence of compassion, problem perpetuating itself, rising inequality and the lack of motivation in farming sector itself. Moving on to the next article of the day that has appeared on page 10 of the Hindu, basically talks about the semiconductor industry in India. Now the article says that the union government has disbursed around 1645 crore in the performance link incentives for electronic manufacturers so far, and it has been seen as its effort to bring in more of the electronic supply chain to India. Now about the semiconductor manufacturing in India, it is today still involved in building circuits, but this semiconductor industry requires high reliable and high quality supply of water, electricity and insulation from the elements. And this industry thus highlights the high degree of precision, cost and capital needed to manufacture these sophisticated circuits. Now through this article, we will try to analyze what basically is the status of semiconductor industry in India, as this topic is important from the GS3 as well as the GS1 perspective, wherein the location of industry is also mentioned under the UPSC syllabus. Now if we look at semiconductors are basically a material that allows conductivity between a conductor and an insulator, and semiconductors are made from pure elements like silicon or germanium. Now, the next question that comes into the mind is that why semiconductors are important. So, the The first important characteristics of semiconductor is that semiconductor makes the devices more compact as well as less expensive plus more powerful. For instance, the mobile phone earlier used to be around 2 lbs and were costing around $4,000 with very less charge time. But today an individual can even buy a smartphone that costs around 5,000 rupees and provides a better charge time. Thus, through the inclusion of semiconductors, there has been a decrease in the cost and the weight of the mobile phone. To understand the importance of semiconductor, this is just an example. Now we will try to analyze what are the location factors for the semiconductor industry and manufacturing in India. The first factor is the workforce. Now, semiconductor manufacturing requires skilled workforce, as we have seen that the semiconductor industry needs precise operations and thus a skilled workforce is required. Not only a skilled workforce, the semiconductor industry to flourish and to function smoothly, a large number of team of lawyers, accountants and management consultants are also required in order to come over the challenges related to patents, management, procurement, etc. The second important factor behind the location of semiconductor industry is the cost involved. Now, semiconductor industry, like any other industry, is cost sensitive and the costing of the final product will depend on the cost of labor, the operational cost of the units, and the services that are being guaranteed at the semiconductor units. The third factor, like any other industry, which is needed for the initial boost is the financial incentives and the subsidies that needs to be provided in the infant stage of any industry. And through this, government can ensure to attract investors, both domestic as well as foreign investors, to set up semiconductor plants. As setting up of a semiconductor plant on a manufacturing unit is a high cost deal and to attain profitability will take some years. Thus, this is very important that the financial incentives and the subsidies by the government are provided such that the cost can be brought down, the profitability of the firm can be ensured, and thus this plays an important role behind the location factor for any semiconductor industry not only in India but around the world. Now moving on to the next factor that is important behind the semiconductor manufacturing is the transportation. Now the transportation is important to ensure forward as well as the backward linkages, and this is important to ensure continuous supply of end products to the consumer. Plus, it is also important to continuous supply of raw material to the semiconductor units. Moving on to the next factor, the infrastructure that is most critical for any other industry as well as to the semiconductor industry is the infrastructure required in the form of continuous supply of water, 24/7 supply of electricity, and the internet access for this industry particularly to flourish. And the last factor that can be attributed behind the location of a semiconductor industry is the market around the area, that is the market availability, and this is dependent on the lifestyle and the demography, and this is favorable for India as there is an increase in the youth population and the subsequent demand, as semiconductors today are the basic building blocks of any modern day technology, and the demand of these modern day technology is particularly high with the youth population. Now that we have seen the location factors for the semiconductor manufacturing industries to be placed, we'll try to analyze the significance of the semiconductor manufacturing industry for India and what step has the Indian government taken to promote indigenous semiconductor industry or to boost the indigenous semiconductor capacity. The first factor here is the economic development. Now we have discussed that semiconductor are today the basic building blocks of any technology, and the indigenous manufacturing of semiconductor chips will not only improve the smartphone assembly industry in India but also create huge employment opportunity. This increased employment opportunity will also lead to the increase in the taxes and the export potential of the country to be explored under the economic dimension, and further will decrease the import bills of the country as now fewer semiconductor chips will be imported. Second significance is the rising demand in the Indian market. Now the article mentions that the Invest India agency has calculated that the electronic manufacturing industry in India will touch worth $300 billion by 2025-26. And experts have estimated that 50 crore people will join the internet. This connection of more people to the internet will increase the demands of phone as well as laptops. Further, the work from home culture that has been introduced through the pandemic also serves the interest of growing demand, and thus it is important to boost the semiconductor manufacturing industry in India. Further, the semiconductor industry will also have geopolitical benefits as it will increase the self-sufficiency of India in this regard and decrease the reliance on countries like that of China, which will help India attain geopolitical benefits as it no longer has to rely on China. At last, the semiconductor manufacturing industry will also enhance the security as the domestically manufactured semiconductor chips will be treated as trusted sources, and over these semiconductor chips, various technologies like that of CCTVs, smartphones, etc. could be made. And what ultimately it will do, it will help in locally storing of data and thus improve the national cybersecurity profile. So now that we have seen the significance of semiconductor manufacturing industry, we'll try to analyze the initiatives that the government have taken in this regard. Now the government, in order to boost the semiconductor manufacturing industry in India, has taken variety of steps. The first step in this regard is the national policy on electronics. Under the national policy, government has envisaged positioning India as a global hub for the ESDM sector, that is the electronic system design and manufacturing sector. Government has also announced SPECS, that is the scheme for promotion of manufacturing of electronic components and the semiconductors, under which the government provides financial incentives, that is up to 25% on capital expenditure on the product that constitutes the supply chain of electronic products. Apart from that, the government is also offering $1 billion in cash to each semiconductor company that set up manufacturing units in India. The government has also announced Modified Electronic Manufacturing or the EMC 2.0 scheme, under which electronic manufacturing clusters and the common facility centers are set up with the government support. We have also seen in the beginning about the production linked incentive scheme, wherein the government provides an incentive of 4 to 6% on good manufactured in India. And at the last, government has opened up the sector for the foreign direct investment, and government has allowed 100% foreign direct investment under the automatic route for the same purpose, that is for the ESDM sector. Despite all the initiatives taken by the government, there are certain challenges that are in front of India. We'll try to analyze what are the challenges in front of India with regard with the semiconductor industry. The first set of challenges is the high cost of establishment that we have seen, wherein to set up a semiconductor manufacturing unit, it will cost around $5 to $7 billion, and this cost is very high and thus deter most of the business houses to take up semiconductor manufacturing in India. Secondly, there is low ease of doing business in India, and particularly this is true with regard to clearances and the approval that are required to set up indigenous semiconductor facility, and these clearances and approval are to be taken from multiple government departments, which further complicates the issue. The third problem that the country today faces in semiconductor industry is the technological constraint. Now the semiconductor industry not only requires skilled labor and precise labor, it also requires high-end technologies. And this currently is the place where India lags, as these high-end technologies are mostly under the patent regime, and these needs to be licensed from the patent holder, and these patents come at a very high prices, and thus the technological constraint also places a key impediment in local manufacturing of semiconductors. The next area that challenges the semiconductor industry is the structural constraint. If we analyze, though government has opened 100% FDI under automatic route for the semiconductor industry, but still the total contribution of FDI in electronics today in India is less than 1% of the total FDI inflow. And the main reason behind such less supply of FDI in the electronic sector has been attributed to the low skilled labor, delays in land acquisition, and the uncertain tax regime that is prevalent in India. At last, the last challenge that India faces is to ensure infrastructure. Now, semiconductor industry, as we have discussed, require water, electricity, and skilled labor. And thus, the semiconductor industry requires 24/7 uninterrupted power supply. And this is the area where it is touted that India will face infrastructure constraint and plagues the sector. So this brings us to the question that what can be done in this regard. The first area that we have identified is that the semiconductor industry requires high investment, and this can be overcome by providing adequate funding, and which can be achieved only by the government support. Further, we have seen that India also faces the issue of technological constraint, and this is due to the patents regime and the high cost of patent that is needed to ensure license. For this, a sovereign patent fund under the National Policy on Electronics needs to be established as soon as possible. We have also seen that there is issue of demand. As for these firms to remain profitable, there is a need for a continuous consumption, and thus there is a need to ensure minimum domestic procurement by the government and the private sector, such that these units or the semiconductor chip units remains economically viable. At the last, as there is a case of low ease of doing business in India, government may also explore the option of acquisition of the already established semiconductor units abroad, and such acquisition will be much easier than setting up a domestic facility. It can also be done in a swift manner. With this, we have seen that what were the challenges of semiconductor industry today faces in India and possible solution to them. We have also seen the initiatives that the government has already taken and identified the significance of semiconductor industry in India. As a part of discussion for the GS1, we have also seen the location factors that are responsible for semiconductor manufacturing industry and thus covered the topic in detail. Moving to the next article of the day, the article is featured on page 1 of the Hindu and basically talks about the defamation case that was filed against Rahul Gandhi, under which now he has been convicted. Now the Congress leader Rahul Gandhi conviction and the sentencing in a 2019 defamation case has put a question mark on his continuation as a Lok Sabha MP. And the experts herein have a differing view whether the conviction and sentencing means immediate disqualification of the MP or whether he will get a time for appeal or not. So this particular case raises primarily two questions, that is disqualification of the elected member of the houses both at the level of center and in the state legislative assembly, and also the criminal defamation and the utility of the criminal defamation in democratic India. Now this topic is important if we see the GS2 syllabus, which mentions governance, polity and social justice, wherein parliament and state legislature, their structure, functioning and the conduct of business is also included. UPSC in the previous year, that is in 2020, has also asked a question in the mains examination where they asked about the need for simplification of procedures of disqualification under the Representation of People Act. Now, during our discussion, we will have a discussion on two topics. The first is the disqualification, that is disqualification and its importance, the constitutional provisions and the Lily Thomas case that is in news with regard to the current disqualification of Rahul Gandhi. And in the second part, we will have a discussion on defamation. What is defamation all about? Defamation as an exception to the freedom of speech. Is defamation a crime? And why defamation should remain a criminal offense or not? Now let us try to understand disqualification first. Now disqualification procedure in India has been adopted primarily to the reason in order to maintain the integrity of the electoral process and ensuring that the elected representatives have follow a certain standard of conduct. And for this purpose, Constitution of India have given certain criteria which have been laid down in Constitution under Article 102 and Article 191, which allows for eligibility of the candidates contesting the election as well as the disqualification criteria. Thus, the disqualification procedure is important as it ensures that the people who are being elected by the public and who hold the public office are the people of high standards of conduct and behavior, and prevents the individual who are basically ineligible and have engaged in unethical or illegal activities to hold the office. So, this is the basic criteria for disqualification to be included under the Indian Constitution. Now that we have discussed the first part, that what is disqualification, why it is important, we will try to understand the constitutional provision regarding the same. And the constitution provision regarding the disqualification can be asked in the prelims examination. And if we see the constitutional provision for the parliament, it is not much different from that of state. Now, if we look at the constitution provision, it says a person shall be disqualified for being chosen as and for being a member of either house of parliament. Meaning thereby there are two classes of citizens here that are being talked about. Being chosen as, meaning thereby he or she is a normal citizen, that is a contestant. And for being, meaning thereby once he is elected. So the constitution makers at the time of formation of constitution did not make much difference between the contestant and the elected person, as the disqualification as under the article 102 lays down the guidelines for being chosen and for being a member of parliament. Now the disqualification as under the article 102 is if he holds any office of profit under the government of India or government of any state, as holding an office of profit will be qualifying as an executive function and will not fall under the legislative function, and thus office of profit and thus holding office of profit is a ground for disqualification. The second ground here is that he is of unsound mind and is so declared by a competent court, and thus the unsound mind person stands to be disqualified. The third criteria for disqualification is that if he is an undischarged insolvent. The fourth criteria is that if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state. Thus, he stands to be disqualified from being a member of a parliament. And the last criteria which has to be seen and is important for us for the current discussion and the controversy is that if he is so disqualified by or any under law made by parliament. And parliament in this regard made the Representation of People Act, under which several provisions which will attract disqualification related to electoral malpractices, etc., was provided for. Now the Lily Thomas case is basically pertaining to this Representation of People Act 1951, which we will discuss later. First we will have a look on the disqualification for the members of State Legislative Assembly. Now Article 191 of the Indian Constitution provides for the disqualification for the members of the State Legislative Assembly. And if you see at the provisions of this article, you will realize that it is similar to that of the provisions as under Article 102. The only thing to notice here is that if he is so disqualified by any or under law made by the parliament. So the law that is made by the parliament, that is the Representation of People Act, or any other law that has been made by the parliament regarding the disqualification process, is also applicable on the state government, and this has to be remembered. Now we'll try to understand the controversy regarding the Representation of People Act 1951, particularly regarding the section 8(4) of the Representation of People Act, which was struck down as unconstitutional by the Supreme Court in the famous Lily Thomas case. Now, in 2013, Supreme Court held that the charge-sheeted member of parliament and MLAs on conviction for offences will be immediately disqualified from holding the membership of the House without being given 3 months time for appeal, as for the case before. We'll try to understand this from an example. Suppose there were two people, person A and person B. Now person B was an elected member of parliament and person A was an ordinary citizen. Now as per the provisions of the constitution as under article 102, person A and person B were to be treated alike, that is on the conviction both the members were to be disqualified from being the member of parliament. But section 8.4 of the Representation of People Act, prior to 2013 judgment under the Lily Thomas case, provided an exceptional power to the member of parliament or the member of state legislative assembly, wherein he was given 3 months time to appeal against the judgment under which he has been convicted. So this made a difference between an ordinary citizen and one who has been elected as a member of parliament and was going against the basic article 14, that is the right to equality. Supreme Court in the Lily Thomas case struck down this provision as unconstitutional that allows the convicted lawmakers a 3-month period for filing appeal to the higher court to get away from the stay of conviction and sentence. Supreme Court in the same case explained that a reading of two provisions, that is Article 102 and 191 of the Constitution, would make it clear that the Parliament is to make one law. That is, law should be similar for a person who has been elected or a person who is aspiring to become one or is a contestant to be disqualified for being chosen as and for being a member, that we have already discussed, as a member of House of Parliament or the State Legislative Assembly. In simpler words, the Supreme Court in Lily Thomas case has done away with the distinction that a elected member of Parliament or the State Legislative Assembly used to enjoy under Section 8.4 of the Parliament, and made no distinction between an ordinary citizen and an elected public official. Further, the court in the same case explained that Parliament does not have the power under Article 102 and 191 of the Constitution to make different laws. Further, Supreme Court in the same case held that Parliament has been vested with the powers to make laws laying down the same disqualifications for a person to be chosen as a member of Parliament or state legislature and for a sitting member of a House of the Parliament or House of the State Legislature. Thus, the distinction or the grace time period of 3 months that was being provided for the appeal to the elected member of Parliament or the State Legislative Assembly was done away with, and if a person is a contestant or a normal citizen, and that being a member of Parliament or being a member of State Legislative Assembly, on conviction, both the people will lose their membership to the House or to be elected as one. Now, this brings us to the next question, that what is the current status regarding the disqualification? Based on the High Court and the Supreme Court order, there are two cases where the disqualification continues and where the disqualification ends. The first is that if a higher court on appeal stays the operation of only execution of sentence, that is, there is a stay on execution of sentence and not on conviction. And the judgment further explains that such a stay on execution of sentence given by the higher courts will not have any effect on person disqualification. Meaning thereby, if a member of Parliament is convicted and sentenced by a lower court, then he will be disqualified. Now, if there is a stay on this sentence, then still the disqualification of the person will continue. Now, in the second case where the disqualification ends, disqualification will be suspended where the higher court stays both the conviction as well as the operation of the sentence. Meaning thereby, if the member of Parliament who has been convicted and sentenced by lower court but has moved to the higher court, and the higher court stays both the conviction as well as the sentence, in such a case disqualification ends. So we have seen the difference when there is a stay on execution of sentence as well as a case where there is a stay on both conviction as well as operation of the sentence. So this was all regarding the disqualification process, and we have also studied about the Lily Thomas case. Now we'll move to the second part of our discussion, that what is defamation. So what basically is defamation? Now defamation can be explained in simpler terms, meaning thereby it is a legal claim involving injuries to one's reputation. Now this injury is caused by a false claim or a fact that has been presented and includes both libel as well as slander. So we need to understand the difference between the libel as well as the slander, as both are punishable in case of India. Now, if defamation, that is injuries to one's reputation by a false claim or statement, occurs through spoken word or gesture, it qualifies as slander. And if an injury or defamation to one's reputation comes in written or printed format, it is qualified as libel. And defamation in India is both civil as well as criminal offense. Now that we have understood what is defamation, now we need to understand defamation as an exception to the right to freedom of speech. Now if we see Article 19 of the Indian Constitution, which provides for the freedom of speech and expression, but at the same time under Article 19(2), wherein reasonable restrictions has been imposed, and these reasonable restriction includes the criteria for contempt of court, defamation and incitement to an offense as some of the exceptions. Now this brings us to the question that why defamation is treated as a crime. Now defamation is treated as a crime because reputation of any individual, that is a general public or general citizen or elected official, is an asset. And any damage to such asset can be legally dealt with, because there may be case wherein the freedom of speech can be used maliciously to bring down the reputation of any individual. And thus the Indian law does not provide for any distinction between the libel and the slander, that is the written form of defamation or occasion in spoken words, and reputation being an asset is the case for defamation to be treated as a crime in India. It brings us to the next question, that why defamation should remain a crime in India. Why defamation should retain its criminal offense? What are the arguments in the favor of defamation being retained as a criminal offense? And what are the arguments against being the same? The first is the arguments in favor of defamation being retained as a criminal offense. The first is that of income inequality. Now, defamation should remain a criminal offense in India because there may be situation where a particular defamer, one who has defamed another individual, may be too poor to provide for financial compensation and may use his financial position to defame the individuals or the public officials. In such a case, it is important that criminal offense or the criminal nature of defamation is retained. The second reason for retaining the criminal nature of defamation is that anonymity that is provided by the internet. Now there is no mechanism to censor internet from within. And in this era of digitalization and social media, online defamation could only be encountered by retaining the criminal character of defamation. Further, Article 21 provides a good ground for defamation to be retained as a criminal offense. Now, Article 21 provides for right to life. It also provides for a dignified life. And thus, it is in the interest of the state to protect the dignity and the reputation of the citizen. And the last reason that why the criminal nature of defamation should be retained is that changes have been made in the law from time to time. Now, defamation is punishable under Section 499 and 500 of the IPC, and now there has been 10 exceptions that have been provided under these sections, that is 499 and 500. And these exceptions clearly exclude ambit of any speech that is truthful or made in good faith or made in the larger interest of public good. And thus the criminal nature is important as the free speech is provided and protected by the changes made under the IPC section 499 and 500. Now moving to the second part of the question, why there is a need to remove the criminal character or defamation being held as a criminal offense. The first point of argument here is that it goes against the global trend. Many countries around the world treat defamation just as a civil wrong and not as a criminal offense. And particularly in 2011, Human Rights Committee had called upon the states to abolish the criminal defamation and highlighted that the criminal defamation intimidates the citizen and gives a chilling effect in highlighting the wrongdoings of the state as well as the society. Now, another argument that goes against the criminal nature of defamation is the misuse by the influential people. Now, the defamation suit is filed against particular individual, and many a time it is seen that it is used as an instrument of harassment. The prosecutor's complaint in many cases, that is one who has filed a complaint against another individual under a defamation suit, is often taken at the face value, and the court sends out routine notices for the appearance to the defendants without any preliminary examination whether the defamation suit has any merit or not. And the process of reappearance and appearance before the court itself becomes a punishment for the defendant, and this highlights the misuse by the influential. Further, scholars around the world have also highlighted that defamation is used as a means to coerce the media as well as the political opponent into adopting self-censorship and self-restraint. The third is the public order concerns that have been taken care by other section. Now, defamatory acts that may harm public order are covered under the other sections of IPC, that is section 124, 153, 153A, etc. And thus the scholars have highlighted that there is no need for a separate criminal defamation under section 499. Thus these were the grounds in favor and the argument against the use of defamation. In this article we have also understood what is defamation, arguments in favor, why defamation is treated as a crime, and the argument against the same.